This trial is no longer just about who killed Senzo Meyiwa. It is about whether truth is still welcome in a South African courtroom, or whether it now comes with consequences. What you're about to hear now will leave everyone questioning Judge Ratha's impartiality. Stay tuned.
My Lord, the court has ruled that Mr. Sifiso Zungu should be present when the matter is argued, but if everyone is prepared to dispense with his presence, we can then
yes,
argue, depending on
yeah, fine, okay.
the inputs by my colleagues.
Mr. Mnisi, what's your...
As it is a court, my Lord, would also have argued that there's nothing that would stop this argument from proceeding on account of the fact that there's no input that Mr. Zungu would have actually, or any contribution in this argument that would have come from Mr. Zungu. So his absence, I don't think, should be a hindrance to the hearing of this argument.
Okay, let's hear Mr. Ramsepe.
As the court proceeds, my Lord, I share the same sentiments as Mr. Mnisi.
Thank you, my Lord. I'm also of the same view. Thank you. That we can proceed in his absence.
Okay, fine. The court differs from all your views. Isn't Mr. Zungu is a witness in this case. He has an interest to protect. But because of the protection which has been caused by the drama in this court, the court is going to order that in terms of section 159 of the CPA, the Criminal Procedure Act, this case should proceed in the meantime. And when Mr. Zungu comes back, the whole evidence which has been relayed in this court, together with whatever documents have been handed up, he will be having full access to those. Okay, but it's incorrect to say that he won't participate. That's not the letter of the law. I can quote the case of State versus Pillay. Case where there was a the former Chief Justice Mpati, Mtata, and Davis. I'm not sure about Davis, but it was a case which concerned that huge robbery in Durban, where they stole about 34 million rands, and where somebody was arrested and promised that he won't be charged if he complies and gives evidence for the state. He was subsequently charged, and he made a statement, and the police unlawfully or illegally tapped her phone, this Indian lady, and they discovered that there was money, the takings of the robbery. That's the mint, were hidden in the roof. Okay, amongst others, that's what the case says. So Mr. Zungu will have access and knowledge of what transpired, and if he wants to get involved with his counsel, he should. More particularly that Mr. Zungu, you must recall, was a Section 204 witness. I don't know whether the state is subsequently going to charge him or not. There's a possibility, perhaps. That's why these interests must be safeguarded. And that case pertinently says that as long as there's no prejudice, if the state recharges him now as a 204 after having given evidence for Mr. Zungu Jr., his interests must not be prejudiced, they must be protected. Okay. Right, let's hear.
Nizobona ke kunencwadi ebihanjiswa ke la incwadi yakhe uSifiso Zungu Gwabini eshoyo ke ukuthi ebeyobona udokotela izolo, udokotela ushilo ukuthi angeke abe nako ukuthi eze enkantolo namuhla ngoba ke usamlindele nakusasa uthi eze kuyena azombona, ukuthi ke udokotela ngokusho kwakhe uZungu uzokona ukuthi abuyele enkantolo ngomsombuluko ngazo i8 kuDisemba inkantolo yasinika umshushisi kanye nabameli ithuba lokuthi ke bathini ke bona kungaqhutshekwa yini noma kulindelwe yena uZungu bonke ke baye bavumelana ukuthi cha kungaqhutshekwa kodwa bisithi inkantolo iyahluka ke yona kuloko ngoba ke kufanele ukuthi ke ngabe abe khona ke kodwa inkantolo isingasho kwamanje ukuthi ngabe qhubeka ke kodwa uma esekhona esebuyile uzokona ke ukuthi noma uzokwazi ke ukuthi konke okushiwo namhlanje noma kukhulunyiwe akwaziswe.
Yes, Mr. Mjuta, I see you here. Are you appearing?
No, I'm not appearing.
What are you doing? Vanishing?
I came to observe the procedure.
Oh, I see. And your colleague is Mr. Mbota. And can I make Ennis? Yes, I noticed that. Okay. Yes, Mr. Baloi, let's comment, please.
As a court, please, perhaps just before we proceed, the court referred to section 159.
Is it 159?
But that section refers to an accused person. I've been looking at section 187 and 188.
Fine.
The witness to attend proceedings and to remain in attendance.
Yeah, right.
So the applicable sections would be
187 and, yeah.
187 and 188.
The 159 is for the accused person?
Yes.
Okay, fine.
I think the only proviso will be that the witness is then excused for
Yeah, for the period is away.
the period that is indisposed.
Yeah, but like I say, his status is not of only a witness. He's made a statement in terms of section 205. Also, if you read that judgment of delay, there's a possibility that he may be charged.
What we are witnessing is not confusion, it is fear. Gwabini did not evade justice. He did not run. He did not hide. He came to court 3 times, ready to testify. And the state turned him away because his evidence threatened to collapse their case. Now that his testimony can no longer be avoided, the language changes. Suddenly we hear about section 205, arrest and prosecution. That is not an investigation. That is intimidation dressed as law. Section 205 of the Criminal Procedure Act is not a punishment clause. It is an investigative mechanism, not a tool to discipline witnesses who disturb the state's narrative. And yet, here we are. When a judge hints at arrest before testimony is tested, impartiality is no longer silent. It is questioned. When warnings sound more like prosecutorial threats, the bench begins to look less like an umpire and more like a participant. A judge's power is not just in rulings. It is in tone, in balance, in restraint. And that balance is cracking. State witnesses contradict one another repeatedly, and the trial adjusts to protect them. But when a witness threatens the state's theory, the system stiffens, the language hardens, and the threat appears. That is not equal treatment. That is selective pressure. And the cost of this is not abstract, it is human. The Meyiwa family does not need a rescued prosecution. They need the truth, even if it is messy, uncomfortable, or humiliating to the state. A conviction secured through intimidation will never heal them. An acquittal achieved through imbalance will never bring peace. What they deserve is a process so clean that no one ever questions its outcome. Yet instead of allowing the case to rise or fall on evidence, what we see is what looks like desperation to save Advocate Baloi from collapse. But courts do not exist to save prosecutors. They exist to test cases and sometimes let them fail. The moment a court begins to protect a theory instead of interrogating it, justice stops being blind and starts looking over its shoulder. This is no longer about Gwabini. This is no longer even about Baloi. This is about whether the courtroom remains a safe space for truth, or whether truth must negotiate with power before it speaks. Because once witnesses fear arrest more than perjury, once judges appear more concerned with outcomes than fairness, and once truth is treated as a threat, justice is no longer delayed. It is being managed. The Meyiwa family deserves answers they can trust, not answers stitched together with intimidation, not justice delivered with a tremor in its voice. Courts are not built to protect cases. They are built to protect the truth. And when truth starts feeling unsafe in court, no verdict, guilty or not, will ever bring peace. The only question history will ask is simple. Did the truth feel safe enough to speak here? Can justice still be trusted if witnesses fear consequences for testifying? Does the appearance of bias matter as much as actual bias? Should contradictory state witnesses face the same scrutiny? Who ultimately suffers when impartiality is questioned? The accused or the victim's family? This is Skybridge. If you believe courts must protect truth, not power, subscribe, share, and keep watching. Until next time, goodbye.